What happens if a trustee refuses to give a beneficiary money? The person who sets up a trust appoints one or more trustees to manage the trust assets for the benefit of its beneficiaries. Under the California Probate Code, trustees have a legal obligation to follow the instructions outlined in the trust instrument when they're administering a trust. As part of this duty, trustees are obligated to distribute money and other assets to beneficiaries according to the directives of that document. Trustees need to thoroughly review the trust to determine when distributions should or need to take place and how much money each beneficiary should receive. These requirements will vary widely among trusts, so we recommend that trustees review and discuss the terms of the instrument with a knowledgeable trust lawyer to ensure they're able to comply. Sometimes, however, a beneficiary will demand money a trustee is not permitted to distribute from the trust. And sometimes trustees refuse to give a beneficiary money they're entitled to, or the trustee has the discretion to distribute. In the first case, the failure to distribute money likely would be a breach. In the second case, the failure to distribute might be a breach, depending on the nature of the discretion given to the trustee. For example, it could be discretion, sole discretion, or even sole and absolute discretion. If a trustee is refusing to distribute funds or a beneficiary is demanding distributions a trustee is unsure should be made, a trust dispute attorney should be consulted to determine what your obligations are. Can a trustee refuse to pay a beneficiary? Sure, a trustee can refuse to pay a beneficiary, but only if the trust allows them to do that. When a trustee can refuse to pay a beneficiary depends on how the trust document's written. Trustees are legally obligated to comply with the terms of the trust when distributing assets. Some trusts give trustees considerable discretion to determine when to make distributions and how much to distribute. In most cases, trustees with this level of authority, this discretionary authority, would be able to refuse to pay a beneficiary if they reasonably believe the request was unreasonable. Other trusts place restrictions on when trustees can make distributions, such as the beneficiary satisfying certain conditions or reaching a particular age. If a beneficiary demands a distribution when the trust instructions preclude it, the trustee must refuse to pay the beneficiary. However, if the trustee's refusal to pay a beneficiary is not allowed or justified by the trust instructions, then beneficiaries have legal options. They might be able to pursue a claim for breach of fiduciary duty. They might petition to instruct the trustee to make the distribution they requested, or they might even petition the court to have the trustee suspended or removed. Often we hear that a trust does not have sufficient assets to make a requested distribution, and in these cases, it might be necessary to ask the trustee to provide an accounting so that you know what's in there and what's not. And that can be either informally or formally through the courts. When can a beneficiary sue a trustee? A beneficiary can sue a trustee for breach of fiduciary duty if the trustee fails to distribute trust assets as required. When a trustee accepts an appointment as trustee, a fiduciary relationship is created between that trustee and the trust beneficiaries. Fiduciaries are subject to the most demanding legal standard, known as a fiduciary duty, which requires them to administer the trust for the sole benefit of the beneficiaries and to exercise reasonable care when doing so. Due to this fiduciary relationship, a beneficiary can sue a trustee when that trustee has breached any of their fiduciary duties. One of the most common reasons we see beneficiaries sue trustees is a failure or refusal to make distributions required under the trust. Some other ways that we see trustees breach their fiduciary duties include 1, embezzling or mishandling trust assets. 2, failing to provide a financial accounting of trust management. 3, engaging in self-dealing or failing to avoid conflicts of interest. 4, paying taxes late. 5, incurring avoidable expenses, fees, and costs. Or 6, showing preference for one beneficiary or one beneficiary class over another. In addition to filing a civil lawsuit, a beneficiary also can file a petition in the probate court to have the trustee suspended or removed. When the judge agrees that the trustee should be taken out, they'll appoint a replacement trustee and potentially order the former trustee to pay money damages, legal fees, court costs, and other expenses, including attorney's fees. When should I contact a trust litigation attorney? If you're the beneficiary of a trust and the trustee is refusing to make distributions you're entitled to receive, or if you're a trustee who's being asked to make distributions you're unsure you can make, you should contact a trust litigation attorney. They'll help you make the best possible determination as to how you should proceed. In some cases, simply filing a petition for instructions with the court might be sufficient. As trustee or beneficiary, a knowledgeable trust litigation lawyer is going to be able to review the circumstances of your case and advise you on your best path forward. Have questions? Give us a call, shoot us an email anytime. The consultation's always free. Thanks for watching.